Okay, we ready to go?
Yes, Your Honor. May it please the Court.
All right. This is Southern Baptist Hospital versus Meek.
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal.
All right.
May it please the Court. Your Honors, the trial judge below made 2 harmful errors with respect to the trial involving Baptist Medical Center by plaintiff Susan Meek. First, the trial judge permitted a witness, an expert witness, plaintiff's expert witness, to change his testimony concerning the location of the plaintiff's injury without providing prior notice to the defendant and an opportunity to inquire. That testimony is critical because during deposition, he identified the location of injury to be in a place that was consistent with the defense theory of causation, but made the plaintiff's theory of causation medically impossible. Then at trial, he moved the location of injury to a different place which was consistent with the plaintiff's theory of causation. The second error, Your Honor, was in precluding the defendant from offering expert testimony in support of its alternate theory of causation. Specifically, the expert testimony of a board-certified gynecologist to testify in support of the defendant's theory of causation that the injury the plaintiff sustained was a complication of gynecologic surgery. Either of those harmful errors are independently sufficient to warrant reversal of the judgment and remand of the case for a new trial on the issue of liability. Now, Your Honors, moving to issue 1. It is an abuse of discretion for a trial court to permit a witness to change their testimony at trial without first providing the defendant notice and an opportunity to inquire. And that's what happened in this case, Your Honor.
Well, now, the trial judge offered you a mistrial twice, didn't he?
He did, Your Honor, and we moved from this trial.
Yes, and then when he told you you could have it, you asked for him to hold off.
Your Honor, you're correct, Your Honor. And the reason that we did was because he offered that at the exact moment that all of this had happened. And it's quite common practice to ask a trial judge to hold a motion for mistrial in abeyance until parties can figure out the consequence of it. But
and the second time the judge offered you a mistrial, the plaintiff agreed that mistrial would be appropriate at that point.
That's correct, Your Honor, which demonstrates the plaintiff's acknowledgement, and in fact his own statement was that he moved for a mistrial recognizing the prejudice that these actions had caused by placing the credibility of counsel in issue. So, Your Honor, if there's any question that the change in testimony was prejudicial to the defendant, it is refuted by the plaintiff's own motion for mistrial.
Well, that can be interpreted in different ways. It could be interpreted as an acknowledgement of prejudice, or it could be acknowledged as a recognition of imperiling whatever verdict was ultimately rendered after several days of trial in this case. And it might have simply been, well, this might not hold up, and so we'll just cut our losses and try to get a new start.
It might be all of those things, Your Honor, but this was done on the very first day of testimony. So I think it's more reasonable to suggest that the plaintiff moved for a mistrial. I take the plaintiff's counsel at his word when he said, I moved for a mistrial because this has placed the credibility of counsel before the jury, and that's not what should be before the jury.
Can you repeat now why you declined a mistrial the second time?
Your Honor, respectfully, we didn't the second time. I think on the very first day, the judge asked if we had any motions. First, we asked the court to strike the testimony and to prohibit the witness from bearing from his deposition testimony. When that was denied, we asked for a mistrial, but we advised the court that we would like the judge to hold it in abeyance just long enough for us to consider its consequence. Now, the very next day, at the end of the day, the judge re-raised the issue. We did not ask, the very next day, the judge raised the issue and denied the motion for mistrial. So I would suggest that there's nothing unusual, inappropriate about asking the court to give us an opportunity in light of the surprise we just experienced.
Well, now, it was the second time the prospect of a mistrial being entered was discussed when the plaintiff's attorney agreed to accept a mistrial, wasn't it?
Your Honor, I don't recall it that way, but perhaps on a paper record it may appear that way. What happened was when this witness changed his testimony, there was an objection. There was discussion about options. Mistrial was referenced during that discussion. Then the judge sent counsel to the library, said, you've got a half an hour to tell me what I should do. And when we came back, mistrial was raised again. And that's when the plaintiff joined in the motion for mistrial. Now, if Your Honor is referring to two opportunities, I say those two offers of mistrial were within 30 minutes of each other. They were essentially all part of the same sequence of events. It was the next day when the judge raised it again that we renewed our motion for mistrial, and it was granted. It was denied.
But the first day when you went to the library and came back, did you demand a mistrial at that point?
Yes, Your Honor. We moved for a mistrial at that time, but asked that the court hold it in abeyance because, again, we were in the heat of having this just occur. The witness had not even gone back to the witness stand to testify yet. At that time, I think it was quite reasonable for us to, as I said, I think it's not at all uncommon for trial counsel to ask the court not to rule immediately, but to hold the issue. It's not as though we waited to the last day of trial.
I want to be completely clear on this, and I don't want you to get panicky about your time. We're going to extend your time.
All right, Your Honor.
It's important, to me at least, to be very clear on this sequence. My understanding is that the first request for a mistrial was accompanied by a suggestion that the court wait. And that thereafter, after this witness had testified further on cross-examination and had made the indication that, in fact, contrary to what had been understood and represented by plaintiff's counsel, that the doctor had received a telephone call a couple of weeks before the trial.
Yes, Your Honor.
That, in fact, when the doctor testified, after the first motion for mistrial, the doctor testified, I believe, on cross-examination. The doctor testifies, no, I didn't get a phone call. We met in, I think, either the doctor's office or in the lawyer's office.
Saturday before trial.
All right. That testimony was given. And then thereafter, there was further consideration of the motion for mistrial. And at that point, that's when the plaintiff's attorney said, I'll accept the mistrial now. And the judge said, no, it's not your choice. It's their choice.
Respectfully, Your Honor, that point is incorrect.
Okay.
Plaintiff's counsel joined in a motion for mistrial before the witness went back on the witness stand. He made his change in testimony. We objected. There was discussion about remedies. One of them was to strike. There was a motion for mistrial. We went to the law library. When we came back from the law library, plaintiff's counsel joined in the motion for mistrial, and it was only then that we asked the court, hold this in abeyance, and the witness was then put back on the stand, testified to the rest of direct, and on cross-examination, when I asked the witness, this attorney called you 2 weeks ago to discuss this. That's how significant this was. The witness 3 times denied that ever happened. And the significance of that, Your Honor, is that demonstrates the lack of any remedy we were given. Because when I attempted to cross-examine the witness, he denied that there even had been a conversation with counsel. And, of course, that's not true because plaintiff's counsel represented to the court, in words of one syllable, that he had called this doctor, that they had talked about his testimony.
Well, plaintiff's counsel said they met, right?
First, Your Honor, he testified, or he didn't testify, he told the judge. The judge asked, did you call this doctor? Yes. When did you call him? 2 weeks ago. So you called him and talked to him 2 weeks ago? Yes. Then the witness, on cross-examination, denies that ever occurred. And so it made cross-examination essentially meaningless. So it deprived us of any meaningful remedy.
Okay, if you want to say more, you can. But I think you've clarified from what I wanted to get cleared up about the sequence of events there.
What I'd like to do, Your Honor, is try to briefly touch on this issue and move to the second issue, because I think it is very critical. The appellee has taken the position and has repeated over and over again that the witness never changed his opinion on causation. Never changed his opinion on causation. Your Honor, we agree, but that's not the opinion that we're talking about. The witness never changed his opinion on the cause of injury, but he changed his opinion on the critical issue of location of damage. Why is that critical? Because the plaintiff's theory in this case was that a clot or a blockage in an artery deprived blood flow to certain nerves and caused permanent injury. To try to get behind the accuracy and truthfulness of that opinion, we questioned the witness in his deposition because we understood that a clot could cause injury to some locations, but could not possibly cause injury to other locations. So the location of damage was critical. In deposition, the witness was handed this exhibit, Exhibit 6 to Dr. Lopez's deposition, and he was asked a clear and unequivocal question. Please mark the areas of damage you claim were injured. That's at page 4 of the second day of his deposition. And in his own handwriting, he drew this box around this precise area on this anatomical drawing. And in his own handwriting, wrote out to the side, ischemic damage, and drew a line to this box. Mark the area where you believe the nerves were injured. And that's what he did in deposition. He came to trial, Your Honors, and completely changed that testimony. He said in direct examination, I was handed a diagram. This is on page 216 of the trial transcript. I was handed a diagram and asked to identify where the injury occurred. Quote, I said it occurred here. That's not right. In Ms. Meek's case, it didn't occur there. It occurred here. And then he proceeded to point not to a diagram or illustration of the spine, but of the leg. He clearly moved the location of injury from a location that he understood and realized could not possibly have occurred from a blockage in that artery. Why? Because this area doesn't receive any blood from the artery that was blocked. Location of damage was critical to the plaintiff's case. They acknowledged it was critical, Your Honors. Plaintiff's own counsel, in the discussion with the judge, among other things, said, quote, Your Honor, if they could prove the injury were 6 inches higher, meaning in this box, if they could prove that, they win the case. In fact, I think he even said, if they could prove that, we shouldn't even be here. So that's how critical this testimony was. Your Honors, he changed his testimony from deposition to trial. We received no notice, no opportunity to
Would that
rebut.
location of injury have been significant, would have been consistent with the testimony of your expert that this injury was a consequence of the hysterectomy rather than the subsequent procedure?
Absolutely, Your Honor.
And that's why this is consistent. It would be corroborative of your theory as to what actually happened in this case.
Exactly, Your Honor. Not just that it undermined the plaintiff's theory, but it was entirely corroborative of our theory of causation, which was that following gynecologic surgery, this patient had significant bleeding into her pelvis. That blood collected and pressed on these nerves because 1/2 to 2/3 of her blood volume was lost following surgery, collected in an area called the retroperitoneum and pressed on these nerves. You know, I see I'm almost out of time, but
Well,
I would like
we're going to extend your time by about 8 minutes, so just go ahead and complete your argument. We took a lot of your time on the mistrial business, but that's important.
I think I've made my point on this, Your Honor. It was critical. It was a change. We were prejudiced because we received no notice, no opportunity to inquire. We clearly could have altered our trial strategy. I would not have stood up in front of the jury, Your Honor, I assure you, in opening statement, and said, every witness will testify that this is the location of injury. And I know that the trial judge would allow the witness to come in and change his testimony and say that that was not the location of injury. Further, Your Honor, as I discussed with Your Honor, Judge Allen, we were deprived of any meaningful opportunity to cross-examine because when we attempted to impeach the witness about this discussion he had with plaintiff's counsel, he denied it happened. And, of course, there would be no way I could impeach him on that because the only reason I knew about it was counsel's representation to the court. This case...
Counsel, did you contemplate asking the court for permission to call in the plaintiff's lawyer on that point?
Your Honor, no, I did not. Respectfully, I don't think the trial judge would have permitted me in the middle of the trial to turn the significance of calling plaintiff's counsel in the middle of trial right after one of his witnesses I think would, respectfully, I just don't believe the judge would have permitted it. So did I consider it? I didn't consider it in a serious way.
I guess I meant to ask, did you do it?
I did not do it, Your Honor.
I'm not
But
concerned.
I asked instead, which we thought was a less significant remedy or request than asking to depose the plaintiff's attorney and then to call him as a witness at trial, was to ask that the witness's testimony be stricken, or alternatively that he be required not to express testimony that was at odds with his deposition, and that was denied. I might also argue, Your Honor, with great respect to plaintiff's counsel, Stuart Ratson, I would not place a plaintiff's attorney on the witness stand who knows his case as well as he does. It would certainly be suicide, I think. So I did not seriously consider it or ask for it. Before I move to the second issue, Your Honors, the case that is most comparable to this one is Belmont versus North Broward Hospital District. It's a 4th District Court of Appeal case from 1999. And the reason it's so comparable is let me remind the court of the facts. In that case, the defendant physicians gave expert witness testimony in support of themselves, of course, in deposition. They testified to several things. First, they testified that there was no hole, no puncture in the plaintiff's aorta. Secondly, they testified they had done a procedure which had the potential to cause a hole, but they had not caused any hole. And moreover, they had not caused the plaintiff's death. In reliance, the plaintiff presented her case arguing that the doctors had punctured the aorta. They admit that there's a hole in the aorta. They caused plaintiff's death. In trial, the court allowed these physicians to testify at odds with their deposition, to testify that there was no hole in the aorta, that they had not caused it, and that they had not caused the plaintiff's death. Now, the witness never changed their opinion on causation, just as in the case here. But they changed their opinion on location and existence of injury, just as in the case here. And it was critically important. And the district court reversed the trial court's denial of a motion for new trial and remanded because it recognized the significant change and the prejudice that was suffered by the plaintiff. And that's what this court should do. With respect to the second issue, Your Honor, it is an abuse of discretion for a trial judge to prohibit a party from offering competent expert testimony in support of their theory of the case. That's what happened here, however. In this case, the trial judge focused on the plaintiff's theory of what happened and plaintiff's theory of causation. And when the defendant called an expert in gynecology to testify that the injury the plaintiff suffered was a complication of gynecological surgery, which would seem to be the appropriate expert, the trial judge, instead of viewing the case through the prism of the defense's alternate causation defense, was sort of fixated, no, it's not meant pejoratively, but was fixated on the plaintiff's theory of the case. Remember, their theory was this was a nerve injury caused by a radiological procedure. And Your Honors may recall that when we asked to call the witness, the trial judge said two telling things. First, he's not a neurologist or a radiologist. He's not competent to testify on causation. And then he repeated that thought by saying he's a gynecologist. He can't testify on causation. 2 points, Your Honor. First, the law in Florida is long well established that a witness is not qualified or disqualified by reason of their area of medical specialty, but by their education, training, and experience. The Supreme Court in Chenoweth v. Kemp said that is the law. It has been the law for years in Florida, and in fact reversed a lower court decision that excluded testimony from neurosurgeons who were called to testify in a case involving a gynecological surgeon. But second, it was an abuse of discretion because the judge, instead of evaluating whether the witness was qualified in the subject upon which he was being called, gynecologic surgery, assessed whether he was qualified in light of the plaintiff's theory of the case. And that was error. In Pascal v. Dozier, the 3rd District Court held in 2000 that it is an abuse of discretion, and trial judges must be very cautious, not only excluding expert witnesses, but particularly so when that expert is called to testify in support of either the plaintiff's theory of the case or the defendant's theory of the case. And in Pascal, again, the 3rd District found an abuse of discretion when the trial court excluded causation testimony, reversed the judgment, and remanded the case for trial. Your Honors, it's unquestionable that we suffered prejudice as a result of being unable to call this witness.
Now, this witness was allowed to provide testimony as to standard of care for the nurses and as to the sufficiency of their performance during the night and that sort of thing. But he was not allowed to offer any opinions as to causation. Now, he really didn't have an opinion as to causation.
Respectfully, Your Honor, he did.
Well, he speculated, I think, is what he actually did about possible causes.
Your Honor, the 4th District held in 1995 in the case of Haas versus Zakaria, and I'm sure Your Honor is familiar with that the plaintiff's burden is to demonstrate liability and causation within a reasonable degree of medical probability. But the defendant's only duty is to deny and to rebut. The defendant has no duty to demonstrate within a reasonable degree of probability.
I'm not questioning anything about the relevance or admissibility of this. It's just that this, if it goes to harm, if in fact it's error, but in fact this doctor did not offer an opinion as to cause. He simply speculated as to potential causes for this condition.
I just disagree with Your Honor's use of the term speculate. He identified 3 possible causes. And the reason he did so, Your Honor, as a gynecologist, you may recall in his proffer, he testified that he has done multiple hysterectomies, that he has had patients who, after the surgery, had experienced nerve injury, just like the plaintiffs. Now, he was not able to say whether those nerves were injured as a result of the dissection, the cutting, whether they were a consequence of the retraction, pulling back the muscles and holding back the nerves, or whether it was a complication or consequence of the bleeding. And because all 3 of those are possible, it would be impossible for a gynecologist to say which of those was probable. And so, respectfully, Your Honor, he expressed an opinion that was not speculative, but not an opinion as to probable cause, but to possible causes. But let me pick up on something Your Honor pointed out. He testified on standard of care, but not on causation. And so what the jury was left seeing was, after we presented to them our position that this injury was the consequence of gynecologic surgery, the cause of her injury was gynecologic surgery, they saw a witness testify on standard of care, a gynecologist, and then not testify on causation. And that goes to the harm, because the jury would have to conclude from that either the witness had no opinion, which he didn't, or that he'd been prohibited from expressing opinions. And, Your Honor, it doesn't make a lot of sense, respectfully, for the trial judge to suggest that we could have called a neurologist to testify about gynecological complications, but we couldn't call a gynecologist to testify about gynecological.
Were you not suggesting that this doctor's testimony was harmful to you?
Absolutely, Your Honor.
It was harmful?
Yes, Your Honor.
Well, you knew before you asked him a single question what he was going to be allowed to testify to and what he was not going to be allowed to testify to. The judge had already ruled on that, hadn't he?
No, Your Honor. The issue of his competence to testify about causation didn't come up until we called the witness and he came into the courtroom and the plaintiff objected for the very first time.
Before the jury had heard any testimony?
Yes, Your Honor.
Well, but the judge made that determination about what this doctor would be allowed to testify to and what he would not be allowed to testify to. And knowing that, you called him and had him testify that way. And now, if I understand your argument, you're saying because he testified as to only one of these 2 things, he was harmful to your case. And if so, why did you put him on?
Respectfully, Your Honor, that's not what I meant to suggest. The harm was that he was to testify in support of our theory of causation.
Okay, so his testimony was of some assistance, but not of the assistance that you would have liked.
It was of assistance on standard of care. It was not of assistance on causation because it was excluded.
Well, we're way over. You
Yes,
wanted a couple of minutes for rebuttal, and we'll give the other side. We'll put 25 minutes on for the other side if they need it. and we'll reserve a couple minutes for you for rebuttal.
Thank you.
Thank you, sir. A couple of minutes, and put 25 minutes on for the FLE so that we can even time on it.
Oh, no, it's fine. Thank you, though. Good afternoon, Your Honors. Kimberly Bolt here on behalf of the appellee, Susan Meek. What I would like to start with, I'll address the issues in the same order as counsel has. We'll start with the issue of Dr. Lopez's testimony first. And what I'd like to do is first back us up to the end of the case when, at the motion for new trial, at that stage of the proceeding, the trial court finally had the opportunity to sit down and in a calm fashion review everything that had occurred here. And I'm going to come forward in time and address some of the issues that Your Honors have specifically raised about timing and things of that nature and what was said at the time. But what I'd like to address first is that once the trial court had the opportunity to sit and read depositions and read Dr. Lopez's deposition and read Dr. Kilgore's deposition and read Dr. Sangstock's deposition, all of whom, Kilgore and Sangstock being the treating neurologists, Dr. Lopez being the expert neurologist, he concluded in his final order there had been no change of an opinion in this case. In the heat of the battle, at the time of trial when this issue was raised, that was very unclear. The judge was very concerned that a change of opinion had been made because of the box issue. And I think the court at that point was rightfully concerned. The plaintiff's counsel was there, and from the very moment this came up, took the position, Your Honor, there has been no change of opinion, there has been no change of opinion. That is absolutely clear from the record, and the defense was contending otherwise. So the court expresses his concern. Now, let's talk for a moment about the timing of the motions for mistrial. I'm not 100% certain about the timing issue that you raised, Judge Allen. I'm not, and counsel may be absolutely correct about that, and obviously the record will bear that out about the second request for a mistrial. But one thing I want to point out is that if you look at it in the context, and if you look at the relief that counsel was seeking, the plaintiffs are here in a position where, because the trial court is concerned that there was a change of testimony, the court was very close to ruling that Dr. Lopez's testimony was going to be stricken, keeping in mind he was in the middle of his testimony, that the jury was we were about to go back, before the jury, and the trial court was going to say, I have now ruled as a matter of law, or however the court would have done it, I am striking the testimony of Dr. Lopez, and he will not be testifying further, and I'm instructing the jury to disregard everything he has said so far. I mean, how prejudicial would that have been to the plaintiff's case? We would have never recovered from that. So I submit to the court, as Judge Allen, you noted, that there could be many interpretations for why at that point in time we said to the court, we then join in a motion for mistrial, is because of the remedies that opposing counsel was seeking. But it is important to note, I think, that the one remedy that they were offered, a mistrial, that they themselves asked the court to postpone.
Counsel, what do you attribute to your witness's statement at trial as he's looking at that diagram and he says that was wrong? That's not where the injury occurred. It occurred in the I believe it's called the ischemic artery, or I'm sorry, I forgot the term.
That's okay.
For that other artery.
Right.
But now, I guess that goes to the remedy of cross-examination, but he says that was wrong.
And let me address that. And I'm actually glad that we have the board here. Because what all of the experts testified to, Dr. Kilgore and Dr. Sangstock, and here's something that I think is very, very important. This is something the defense doesn't address. In their depositions and in their medical records, Sangstock and Kilgore diagnosed Mrs. Meek with, and I'm quoting, lumbosacral plexus injury or lumbosacral plexopathy caused by ischemia. Okay. Now, the defense never contended at trial, because we called Sangstock and we called Kilgore. They never contended at trial that either of those two doctors changed their opinion from their deposition testimonies. So, since they used those terms and they referred to it as a lumbosacral plexus injury caused by ischemia, the defense knew what their argument was going to be. All this is semantics. This is the bottom of the spine. This is where inside the box is where the nerves originate. The nerves come down the leg, or actually it's the hip. They come down this side of the hip bone, and it's down in this particular area. And excuse me, Mr. Fuge knows medicine more, probably a lot better than I do, but I believe the nerves that were actually injured, the peroneal, the tibia, and the femoral, they are down here. We know for a fact, because it was introduced into evidence in this case, that the occlusion occurs north of those, and I don't know that I'm pointing to the exact location, but we know that the occlusion occurs north of these nerves. We have it on film. So the question then is, why are the neurologists using the term lumbosacral plexus injury if this is the lumbosacral plexus? And Dr. Kilgore explains it, and then Dr. Lopez explained that when he was then on cross-examination. Neurologists think of the spine in segments. What they care about is the brain working, is the spine working so that it's working the legs. If there's not paraplegia, then why is this one leg paralyzed as opposed to both legs being paralyzed? And so they think of the spine segmentally. So they will call it a lumbosacral plexus injury, even though the occlusion is outside of the box. To them, it is called a lumbosacral plexus injury, because what they care about is the fuse box. And that is why he drew the picture there. And I think another important thing to consider when Your Honors look at this is on page 13 of our brief. The defense, when they make this argument, they never refer back to the deposition testimony where he actually drew the box and what he actually said when he drew the box. The question was, can you mark, and I'll give you my pen, or if you have a colored pen, or maybe I do, and mark the areas you believe the nerves are injured? Answer, let's make it simple. You can get really distracted with all the minutia of the anatomy of her arteries. What happened? The big picture is that the aorta divides into two common iliacs. The answer goes on. I'll skip ahead a little bit. The external iliac is the artery that goes to the leg, and the nerves that go to the leg, and basically an external iliac lesion and external iliac come off of L4, L5. So again, now this is the thought process of the neurologist. They come off of L4, L5. So again, see, he as a neurologist is relating it back to where are these nerves coming off of the spine? Something like that, and I believe that's where he draws the box when he's referencing L4, L5. There is a lot of variability person to person, but that obstruction is more likely than not what occurred in Mrs. Meek. Now we know, because, and it's undisputed in this case, that the obstruction occurs down here because we have the actual radiographic film of it. Then he goes on and answers the next question. There are nerve segments that are involved, including most of the nerves back to S1. Now, it's hard to see on here, but here's S4, S3, S2, S1 is about right here. Back to S1. And then he says, clinically what occurs is that the external iliac is occluded. That's down here. The external iliac is occluded. And what you're talking about is affecting the nerves to the leg. That is his statement when he draws that box. And so,
Believe it or not, I think I really actually understand what you're saying. But this question is, and it's the question I ask is if the injury was up there where the box is, would that be consistent with the appellant's theory as to what happened here? And the answer was yes. But now, if the undisputed location of the occlusion is, as you say, down there at or beneath the hip,
correct.
How is that reconciled with their theory that the injury was higher and as a result of something that happened during the course of the hysterectomy?
When the bleeding occurred from the artery, that's a common complication of hysterectomy, the bleeding that occurred. The bleeding is pooling in the area which sits on top of this area. So the defense's theory was compression, that there was a lot of blood, she lost a lot of blood, and that the blood was compressing on her.
Okay, so the collection of the blood from an occlusion from below was in that area, and that was the reason.
Right. And so that it was the blood from the cause. I was about to say natural cause, but a common cause of the hysterectomy. It was the blood pooling from the hysterectomy that caused the damage to the leg, and that the occlusion that we see on the film is just coincidence. That's the defense's theory, is that the occlusion that we see on the film is coincidence.
Okay.
And so that's why the box matters to the defense.
Right.
But I think that that's why we repeat the mantra when you go back to what we say. He never changed his opinion. They asked him about the opinion of retroperitoneal hematoma. They asked him about the pooling of the blood. Well, isn't this really caused by the pooling of the blood, the retroperitoneal hematoma? Overwhelmingly, no. So he never intended for this box to support the defense's theory of the case.
So your argument that as counsel for the defense took a risk and characterized that testimony as perhaps they would like it to be characterized, and your witness, when he says, oh, that was wrong, and he meets with your trial counsel, I assume in a fairly intensive meeting, and then comes forward and clarifies his testimony, that that's just part of the risk of the trial strategy, and reversal is not mandated under those circumstances.
And I think that's absolutely correct, because it's not a change of opinion. His opinion was always that the occluded artery was the cause of the injury to her leg, and in fact, he very affirmatively stated it is not the retroperitoneal hematoma theory.
In the deposition, he says that.
In the deposition, overwhelmingly no.
Okay, then let me ask you a question, if you can answer this.
Sure.
Why the need for plaintiff's trial counsel to meet with the witness 2 weeks before trial, and plaintiff's trial counsel repeatedly stating at trial, I wish I had informed the defense, I moved from this trial with tears in my eyes, I wish to gosh I would have done it. They meet, something does change. Now, whether it's characterized as a clarification of, well, yeah, I drew that box, but really it was the external iliac that injured the plaintiff's leg. It was not the lumbosacral plexus. Something required plaintiff's trial team to focus on that testimony fairly intensely.
And you know, it's the way things happen it's always interesting. Mr. Ratson didn't defend this deposition for the plaintiffs when the depositions of Dr. Lopez was taken. It happened to be his partner. So Mr. Ratson hadn't focused on all of this until he was preparing for trial. Obviously, the easiest thing to have done would have been to have clarified the box issue at the depot. I think that I agree with Your Honor when you say that the defense took a risk. I think what proves that they took the risk is what were they going to say to Kilgore and Sangstock. In other words, for one moment, let's put aside Lopez. They knew going in, if Lopez had never drawn the box, they were still going to make this same argument, and they were still going to be faced with what was the explanation going to be from Sangstock and Kilgore as to why these very well-respected neurologists, one of which is chief of staff at their hospital, testified that it was a quote-unquote lumbosacral plexus injury. And Dr. Kilgore said it best, you're splitting hairs because it suits you. He said that to Mr. Googe on cross-examination. You're splitting hairs because it suits you. We think of neurological injuries in this segmented fashion, and that what matters to us is what's happening with the fuse box. The injury can be anywhere along the pathway. The injury could be in the calf. The occlusion could be in the calf. and so that maybe, let's say you lose use of your foot, but they are still going to call it a lumbosacral plexus injury because of where the nerve originates from in the spine, which is what they care about. So I believe it was a risk that they took. Now, going back to counsel for a moment, I think that if you look at what was happening in the heat of the moment during the trial at the time, the judge was very, very concerned that there had been this change of opinion. And what we have is a huge, ultimately in the end, because the judge concludes there had been no change of opinion, we have a tempest in a teapot. And we're sitting there, and I think Mr. Ratson makes it very clear on the record, had he known this was going to create the problem that ultimately developed at trial, he would have said something. Because, you don't spend all that money, you don't want to go to trial to have a problem like this. You don't want to be in these shoes.
He knew it was a potential source of problem for his case, which is
Absolutely.
why he met with the doctor 2 weeks before the trial. And
Well,
it's a little different. It's a little difficult, I think, to say that his hands are completely clean in this, because he was concerned enough about it that he got with his witness and made sure that he understood, and
I agree.
was prepared. And even in the direct examination, he was careful before any cross-examination to have this doctor explaining and reconciling these two pieces of testimony. So it's a little hard to just talk about the defense taking a chance. I think the plaintiff is taking a chance here too, it seems to me.
Well, I think that I don't disagree with what you're saying, but I think that if there had been any, and maybe there should have been, but if there had been any thought that this was going to create the problem, I mean, we're now here talking about it on appeal, and, if there had been the thought process then that this was going to be such a problem, I mean, everyone's actions may have been different.
But I mean, counsel, the witness, and I don't mean to signal a view on this one way or the other, but the witness at trial says, I may be paraphrasing so you can correct me, that is wrong. That is not where the injury is. The injury is in the external iliac artery. I was wrong. And you can recharacterize it or go straight to the record on that. But I guess my question is, does trial counsel have an obligation under the rules of discovery and under the case law to call opposing counsel and say, I was preparing my witness for trial, and I want you to know that he thinks he may have given you some misleading or confusing information regarding the causation in this case. I just want you to know he's going to testify at trial that it was an injury to the external iliac, not to the lumbosacral plexus. That we neurologists think in these terms, and hey, I just want you to know that. That came out of our preparation. Be forewarned. And then they might say, even 2 weeks before trial, well, will you agree to a deposition, a follow-up supplemental deposition on this issue? I don't know what would have happened or any harm that may have occurred from the lack of that procedure. I guess my concern is, does Florida law require trial counsel to provide that courtesy or that information, if you will?
I think it requires you to provide that information if it's a change of opinion. But I think that you don't have to go through depositions, particularly expert witness depositions, and foresee every factual distinction that could be made and have to call up opposing counsel about that. I don't think we'd ever get to trial.
Let me ask it this way, then. A witness says, that is wrong. That I drew, that I said, that location where I said the injury occurred is wrong. Now, this is a challenging issue. I don't know how to particularly characterize that, but is that a clarification with your witness? Or is that let's say it's not a 180-degree change in testimony. Let's say there are two poles in the 4th District Court of Appeal decision. Shows one pole. Yes, there's a hole in the aorta. No, there isn't. I understand that distinction.
Those are pretty clear, those
Right,
cases, right?
Whereas here is somewhere on that line. It's not, I would suggest to you, innocuous. It's not insignificant. It's not of little import, but it's a major difference. I'll avoid the use of the word change. It's a difference in the testimony, right? It's different testimony than was at the deposition.
I don't know that I 100% agree that it was different than what's in the deposition. When you, and that's why I really ask Your Honor to look at page 13 and 14 of our brief, where we set out the questions and answers that were there. And when you look at those questions and answers, and keep in mind that this is when he's drawing the box, I think the problem with his answer is he doesn't go on and say, now I just want you to know that we neurologists think of the lumbosacral plexus as the, he didn't go on and further explain what he meant by the box, that this is we call it a lumbosacral plexus injury, and so that's where he draws the box, but the occlusion occurs further down the line. And he's very clear on that right here in the answer where he draws the box. Clinically, what occurs is that when the external iliac is occluded, you're talking about affecting the nerves to the leg. So to me, it's sort of similar to like an accident reconstructionist, an expert who comes in and says, okay, I've done all of my calculations about how the accident occurred, and the one party was going at, let's just pick a number, 60 miles an hour, and in my calculations, I've used 60 miles per hour. And then later in his deposition, he makes the mistake of saying he calculated it at 65 miles an hour, when everyone knows he calculated it at 60 miles an hour. That is a change. That's clearly a change, but it's a factual mistake. It's a clarification. And I think that all he was doing here was ultimately explaining what they were never going to be able to get around with Dr. Singstock and Dr. Kilgore. And the defense questioned them at length on cross-examination.
So your argument then is that, and that's a helpful response, but your argument then is that the defense trial team was trapped by the evidence, and thus they took this lack of clarification, lack of explanation, medical shorthand term that the doctor used, and they based their entire trial strategy on convincing the jury that disregard the occlusion, the doctor said the injury occurred, and because the injury occurred there, it's impossible for what the nurses did to have caused this injury.
It's a little bit broader than that, but I think I agree with what you said, but add to that they were relying on the findings in Singstock and Kilgore's treating records, lumbosacral plexus injury. So it's Singstock and Kilgore's diagnosis along with Lopez's box. Now, and what we say about that is, how can you believe that all three of these doctors are speaking a completely different language? All three of them are not saying the exact, all three of them are saying it's from the ischemic injury caused by the occlusion. So if something isn't making sense, you've got to figure out, why is it not making sense? Why are these two things not jiving? And what we say, all three of these doctors, is because we're not speaking the same language, because you keep using this very strict anatomist view of the word lumbosacral plexus, and we're using it differently. We're using that term differently. And that's where I think, that's what I think the defense did. But my point is, they were always going to have to overcome Singstock and Kilgore's response to this question. And in fact, I believe we quote it in the brief, where they're cross-examined, and Mr. Gooch cross-examines Dr. Kilgore and says to him, well, you would want your diagnoses to be accurate in your medical records, and please tell me, doctor, you're not going to put down some inaccurate diagnosis. You're not going to use terms that you don't really mean. And that's where Dr. Kilgore gives him the very cogent explanation. you're not thinking like a neurologist. You know, you're thinking like a lawyer. And you're splitting hairs because it helps your position. But we as neurologists talk about the segmental, you know, how injuries, you know, form along the spine in a segmented fashion, and that's what matters to us. That's why we use the term lumbosacral plexus injury.
So in your view, reading the deposition in context, a reasonable attorney would not have been misled into believing that your witness was going to testify that the causation of the injury was in the lumbosacral plexus.
I think that a reasonable lawyer would know that that's where all of this was going. And I don't fault the defense for wanting to use that information to their benefit. I don't fault the defense for wanting to suggest to Dr. Kilgore and Dr. Singstock, well, you said in your diagnosis lumbosacral plexus injury. What do you mean by that, doctor? Didn't you really mean this and not that? I think they have the right to do that. But I think to suggest that this whole thing came clearly out of the blue and that they had no foresight that this was coming, I just suggest that that's not particularly plausible since they knew what Kilgore and Sangstock were going to say, and they knew it was exactly the same. And okay. I know I'm done. I didn't address Dr. Salkind really quickly. The only thing I want to say about Dr. Salkind, he has never treated a patient in Mrs. Meek's position. He testified to that. This is a case about neurology. Even if it's a retroperitoneal case, a retroperitoneal hematoma case, that's a neurological injury. They had a wonderful expert come and testify at trial, Dr. Bomey. Dr. Bomey testified all about that this was the result of a retroperitoneal hematoma, and the court gave them the opportunity because, keep in mind, Salkind testified before Bomey, and the court said to the defense counsel, you can ask Dr. Bomey, who's far more qualified than Dr. Salkind, all of the questions you want to about possibilities. And they elected not to do that. So we submit that there's no error in connection with either of those points. Thank you, Your Honor.
Okay, thank you. We have a short rebuttal now. Complete the argument.
May it please the Court. Your Honor, Appley's position was best stated at the very beginning of her argument, at the very end of her argument, where she said, Dr. Lopez never changed his opinion. And you heard her repeat that over and over again. But the opinion, the it in that sentence, is the key. He never changed his opinion on causation, but he clearly changed his opinion on the location of injury. So it's not enough to stand up and say, the trial judge looked back after the fact and read the depositions and concluded the witness never changed his opinion. Because what the trial judge said in his order was, quote, the question for the answer sought was there a change in Dr. Lopez's opinion on causation at trial from that rendered in deposition? The trial judge was focused on exactly what Appley's counsel is trying to have this court focus on. There was no change in causation testimony. We've never claimed there was a change in causation testimony. There was a change in the location of injury. Now, ultimately, that's what it all boils down to, is was this a change? Was it a material change? We suggest several things. Judge Thomas, you said, isn't it, to paraphrase, isn't it significant that the witness himself said, that's wrong? He didn't just say that's wrong. He said, I said it was here. That's not right. It wasn't there. It was here. Those are his words. On direct examination, I won't put any words in his mouth. This wasn't cross-examination. Number two, counsel said, we always said there was never a change. That's not accurate, Your Honor, because plaintiff's counsel, when I objected and we had sidebar, said to the judge, Harrison, quote, the purpose of Dr. Lopez changing his testimony is to explain an anatomical fact. The purpose of him changing his testimony, not clarifying, explaining, tweaking it a little bit, changing. That's at page 220 of the record, Your Honor. He acknowledged the significance of it when he said 6 inches higher and they win the case. And Your Honor, they can talk all they want to about semantics. Well, when neurologists use the word lumbosacral plexus, they don't really mean lumbosacral plexus. Well, that was something we never heard in deposition. But whether they mean lumbosacral plexus or lumbosacral plexopathy, this picture is not subject to that argument. It's not the words, it's the drawing. He wasn't asked to draw a box around the lumbosacral plexus. He was asked, quote, please identify the area you say was damaged. That's where he drew it. And then he came in trial and said it's wrong. After meeting with counsel, after counsel admitted that he should have called us, all he had to do was pick up the phone. The law requires notice and an opportunity to inquire, Your Honor.
All right.
Thank you.
We appreciate your argument, and I think we actually understand all of this. You'll be hearing from us. That completes the arguments for the afternoon. The court will be in recess.